everyone. Welcome to Management 413, Employment Law, here at the UAB Collat School of Business. In this video, we will be covering work-life conflicts and other diversity issues using Chapter 11 of our textbook, Employment Law for Human Resource Practice. Here's an outline of what we will be covering: the Family and Medical Leave Act, language requirements, national origin discrimination that might arise from that, and discrimination based on sexual orientation. As our workplaces become more and more diverse, the greater is the likelihood that we will have conflicts between professional lives and personal lives. Workers who are increasingly female, older, or disabled may require leave for taking care of their own medical problems or for parenting. Workers may leave to serve in the military. Workers may have difficulty with English-only language requirements. And last but not least, gay, lesbian, bisexual, and transgender individuals may encounter difficulties in the workplace, balancing those with their personal lives. The Family Medical Leave Act is a very important law for all of you as HR professionals. You will, I think, spend a great deal of your time, a surprisingly large amount of your time as a professional working on this law. If your experience is like mine has been, you will find that there are a number of employees who know a great deal about the Family Medical Leave Act. Perhaps you might think from time to time more than you do. It applies to all governmental employers, and as far as private employers, any private employer with 50 or more employees. Some states might have their own leave laws. Whatever your organization's policy is for leave for any reason, if you are covered by the Family Medical Leave Act, your policies should be consistent with that law. It is against the law to interfere with an employee's FMLA rights. Here are the elements of a claim that that's been the case. We'll be looking at the eligibility for FMLA in just a second. First, as I said, the employer has to be either a private employer with 50 or more employees or a government employee. Beyond that, for the FMLA to apply, you have to look at the length of time that an employee has been with the company, the number of hours worked by the employee before making the request. You can see here that the employee has to have worked for the employer for at least 12 months and must have worked at least 1,250 hours in that 12-month period. Very importantly, there has to be a qualifying event for which leave is needed, and also very importantly, adequate notification to the employer is required. What are qualifying events? Look at these carefully, because not every type of an event in someone's personal life qualifies for leave under the Family Medical Leave Act. Birth of a son or daughter, placement by adoption or foster care of a son or daughter with the employee, need to care for a spouse, son or daughter, or parent with a serious health condition. Note that it's not a nephew or a niece or a grandparent or an aunt or an uncle. The law is very specific. Your organization's policy can be broader than that. Perhaps your state's policy can be broader than that. Another qualifying event is the inability of an employee to perform the functions of his or her job due to a serious health condition. As we'll see in a minute, the definition of serious health condition is extremely specific. Next, the need to care for a service member who suffered a serious injury or illness while on active duty is a qualifying event. And finally, look at the concept of qualifying exigency. This is an emergency arising because a family member is or soon will be placed on active duty in the military. What is a serious health condition? Look at the requirements here. Clearly, someone who is an inpatient in a hospital would have a serious health condition. Someone who is requiring continuing care by a health care provider during a period of incapacity is someone who may qualify for a FMLA leave. Note that in either case, either a hospital stay or continuing care has to result in 3 or more days of incapacity and treatment. Note that pregnancy uh, might apply, but not all pregnancies are serious health conditions. If you have a long-term period of incapacity, that is likely a serious health condition. What are the requirements of employees who believe that they qualify for FMLA leave? If the need for leave is foreseeable, they have to provide their employer with 30 days notice. If they fail to provide that notice, the employer may delay their leave until the 30-day notice requirement is met. If the need is not foreseeable, the law says that employees must provide notice as soon as practicable. There is a simulation on this topic, Chapter 11, Question 2, that a pair will be assigned in the class. The employee who was absent 6 times in 12 months and after a final warning showed up for work but then quickly told her supervisor that she was sick. Does that meet the notice requirements of FMLA? Here's an interesting case involving a common problem in many employer settings. Here's a nurse who had attendance problems, and like the question in the simulation, called her supervisor with very little notice to say that she was about to start FMLA leave. What must employers provide once the employee has given adequate notice? Up to 12 work weeks of leave over a 12-month period. Note that the leave does not have to be paid. It might be paid if the employee had sick leave, paid sick leave accumulated. The employer has to maintain health insurance. The employer has to restore the employee after the leave is up to the same position held or an equivalent position, and the employer may not retaliate against someone who exercises his or her rights. Here's a simulation that 2 of you will be assigned to. An auto worker who was delayed from her return from FMLA leave for a serious health condition. Was the employer in the right or in the wrong in the way it handled that return to work? Here's another FMLA simulation that 2 of you will be assigned to. The employee whose daughter suffered a serious head injury and took FMLA time to care for her, but it was discovered that he was caring for his yard and making his house safer for her return by doing some improvements around the house. There's a very interesting concept in FMLA called intermittent leave that allows an employee under certain circumstances to take his or her leave not in one big chunk of time, but to take it in bits here and there, perhaps by working only mornings, perhaps by not working on Mondays or Fridays. This can cause problems for employees and often results in disputes, but in theory, it is permissible under FMLA leave. Employers should respond promptly to requests and start a dialogue. Employers are required to give notice to employees that any leave that they're taking is going to be designated as FMLA leave so that employees are aware that the 12 weeks that are allowed by the law are ticking by. There's another law apart from FMLA called the Pregnancy Discrimination Act. Note what the name of that law is. It prohibits discrimination based on pregnancy. What that means is that employers have to treat persons with pregnancy-related conditions, such as, for example, the inability to walk around easily, as a woman might experience after giving birth, has to treat them in the same manner as they would treat someone else with a different medical condition, such as a man or a woman who's not pregnant, who was unable to walk around for some reason. It is not a leave law. It is an anti-discrimination law. We also have demands on our time from time to time. to serve on juries. The Jury System Improvements Act protects people who serve on federal juries and protects by protecting them from discharge or being intimidated. Generally, the purpose of the law is to make sure that we all are able to serve on juries. Military members are also protected from demands, conflicts that might arise between their military service and their regular jobs. The Uniformed Services Employment and Reemployment Rights Act, sometimes called USERRA, says that employers may not discriminate against members of the military. Employers have to re-employ members of the military following up to 5 years of cumulative absence. And importantly, employers must try to place returning veterans into the positions they would have attained had they stayed there and continued to be promoted. This is called the escalator principle. We have a simulation on this. An employee in the National Guard whose supervisors in his regular job told him he should get out of the National Guard because of all the scheduling inconveniences it was causing his employer. There is a lawsuit that you can bring if you are not reinstated in time as a military member when you want to return to your job. Here are the elements of a failure to reinstate case under USERRA. Here's a case in your textbook. Make sure you understand what happened here. An employee was seeking to get his job back after being in the National Guard, and he experienced some pretty serious delays in getting reinstated, and the court found that the employer had violated USERRA. What about language requirements? Sometimes there will be a requirement at an employer for English fluency or for perhaps the absence of an accent. This type of a requirement poses some real concerns under Title VII of the Civil Rights Act of 1964 because it could be a pretext for discrimination against someone based on their national origin, which of course is a Title VII protected class. There are exceptions that would allow an employer perhaps to require an English speaking person not to have a distracting accent, where it was important that that be the case. Look at the case on page 407 of the textbook involving a motor vehicle bureau in Hawaii that rejected a Filipino with a heavy accent, even though he had the #1 score on the civil service exam. Employers who institute an English-only rule in the workplace are likely to run into trouble. The Equal Employment Opportunity Commission says that English-only rules are presumptively discriminatory and will only allow an English-only requirement to be used if it is very narrowly tailored and if it is a business necessity. That might apply, for example, in a motor vehicle job. Finally, we have the issue of sexual orientation. Title VII does not include as a protected class one's sexual orientation. In 1964, people weren't talking about that, at least. Title VII has been interpreted in its prohibition on discrimination on the basis of sex to include some in some cases, some instances of discrimination against people based on their sexual orientation, but it is not at all clear. Public employees might be a little bit better protected because it may be that if there is discrimination against someone on the basis of their sexual orientation, that person could argue that their equal protection rights under the Constitution are being violated, and public employers are required to comply with the Equal Protection Clause. Remember that bans on same-sex marriage were just struck down as violations of the Equal Protection Clause. Whether or not you are going to get protection for your sexual orientation depends upon where you live. The U.S. government, as I just said, does not protect you in all 50 states, but there are about 21 states plus the District of Columbia that do have some protection, and there might be some local laws as well. And of course, you as the employer have to comply with them. Transgender people have increasingly been in the news. Caitlyn Jenner has done us all a favor by bringing this into the open. There is no federal law that protects transgender people from discrimination in the workforce. There will likely be state and local laws, an increasing number of them, and your organization's human resource policies may cover transgender, just as UAB does, for example, and make it illegal, make it against the policy, at least, to discriminate against someone on the basis of his or her gender identity. Remember this picture from earlier in the course where the mayor of New York was passing a New York City ordinance making it illegal to discriminate against someone in New York City, in a workplace in New York City, based on his or her gender identity. That's it for this set of slides. In our next learning module, we will be looking at wages, hours, and pay equity.